Oh, wow, my bad. I apologize. We do have a new member for this case. You and Greenholz look a lot alike. To my right is Judge Jill Ayers from Nashville, joining us on this case because Judge Greenholz has a conflict, so she has kindly agreed to step in on this case with
Glad
us.
to be here.
Thank you. You may, and do you owe any time for rebuttal?
Yes, Your Honor, I would reserve 5 minutes for rebuttal. Thank you.
All right, thank you.
May it please the court, counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. The state respectfully asks this court to reverse the trial court and vacate its order granting the defendant's motion to depose his brother and the state's chief witness in this case, Christopher Martinez. In this argument, I will try to refer to the defendant as the defendant and his brother as Mr. Martinez. If I mess that up, please feel free to correct me. But since they are brothers, that's what I intend to do. The trial court abused its discretion when it granted the defendant's motion to depose Mr. Martinez. Tennessee Rule of Criminal Procedure 15 governs the taking of depositions in criminal cases. Notably, the trial court's order granting the defendant's motion nowhere mentions Rule 15, nor does it analyze the motion under that rule. The trial court's failure to apply the correct rule, Rule 15, by itself constitutes an abuse of discretion, and the state respectfully asks this court to reverse. Moving on more substantively, Rule 15 provides that a party may move that a prospective witness be deposed in order to preserve testimony for trial, and it also provides that the trial court may grant the motion because of exceptional circumstances and in the interests of justice. So Rule 15 permits a deposition in a criminal case for one purpose and one purpose only, and that is to preserve a witness's testimony for trial. And then, even if the purpose is correct and the deposition is only to preserve testimony for trial, that deposition can only go forward and the court may only grant it if the witness is shown to be unavailable for trial due to exceptional circumstances. And here the defendant concedes that the purpose of the deposition is not to preserve Mr. Martinez's testimony for trial. Instead, he claims that he's entitled to depose Mr. Martinez based on his accusation that the state is withholding Brady information. But Brady simply requires the state to disclose material and exculpatory information, as this court is well aware, to the defense, and it functions as a post-trial remedy for the state's failure to disclose such information before trial. That is, Brady is a post-trial remedy meant to encourage and to strongly encourage pre-trial discovery. And therefore, what the defendant is asking is his request for a Brady deposition is nothing more than a request for a discovery deposition.
What was the trial court's basis for allowing this? Because if I understood the order, the trial judge did not necessarily make the finding. I'm not disagreeing with you that Brady's a post-trial issue, but she didn't make the finding that the state was withholding anything.
No, that's right. As far as
So what's the basis for the deposition then?
Your Honor, I don't know. I don't know
Fair.
what the basis is. Basically, as I understand it, the defense simply does not believe, or let me rephrase that the defense very strongly believes that the state is withholding information.
Well, let me re-ask my question then. Maybe I didn't. What was the trial court's legal basis for allowing the deposition?
As I understand the order, the basis is simply based in the defendant's motion and the arguments that the defendant made, which were based in his Brady arguments.
So the trial court found the state's not necessarily withholding anything, Brady.
That's
but even though the defendant's claiming they are,
right,
she then allows the deposition based on their claim, even though she's already found their claim to be meritless in a sense.
In a sense, yes. So, I mean, as the court is well aware, I mean, typically in a Brady case, what will happen is the defendant will appear after trial and the defendant will come in with a piece of evidence, whether it's a document or a witness or something like that, and he'll say, you see, I asked for this information, the state had it all along, and the state suppressed it, didn't let me have it, and the trial would have been different otherwise. And we simply don't have anything like that here. What we have is speculation that the state is withholding information, or on the contrary, I do think as I look at the defendant's brief, I think he makes an argument that the state is required to review all of its documents, all of its case file, and then to essentially highlight all of the things that it believes may be exculpatory and material, so that so that the defense can review it. I think that's the issue. In either case, I don't see that a deposition is possibly the cure. First of all, it's not permitted under Rule 15, and second of all, whatever information the defendant may be able to glean from Mr. Martinez in a deposition is information contained solely in Mr. Martinez's mind. And when we're talking about Brady, we're talking about evidence that is solely within the possession of the state, or and that the state has and the defendant can't get. So
let me ask a follow-up question to Judge Dyer's question. I did look at the trial court's order on this, and it really is very brief. It's one page, and I haven't dug into the record. Is there going to be more in the record where the trial court explains the ruling for granting the motion?
That may be in there was a hearing on it, and to be honest, Your Honor, I don't remember exactly what how the trial court reasoned this out in the hearing. So I'm not going to. I mean, the record will bear that out. Regardless, what the trial court didn't do is analyze anything under Rule 15. The trial court didn't go and say, yes, this deposition is taken to preserve Mr. Martinez's testimony for trial, and yes, the defendant has proven that Mr. Martinez will be unavailable for trial and that he will be unavailable for exceptional circumstances. The trial court simply made no such finding, either on the record or in its written order. And
even if the trial court didn't make those findings, is there any proof of those facts?
Of which facts? I'm sorry.
Of facts that he would not be available and that there is a need to preserve?
No, there's absolutely no evidence to support any of that. In fact, the only evidence that the defendant even posits in his brief is, well, the state simply hasn't given us strong assurances that Mr. Martinez will appear for trial. And I think some of that goes to perhaps the defendant's experience with his brother in a lot of these civil cases. There's civil cases that go back and forth between these two. This is not a family that I would want to be part of. Quite frankly, it seems like it's a mess. But the fact of the matter is, these guys are suing each other back and forth, and so I think there's some behavior that the defendant may be relying on. But here, this is a criminal case.
Back to the question: is any of that in the record?
No, none.
We don't. Case.
No, none of that's in the record. And as far as I know, the defendant hasn't put up any evidence that Mr. Martinez won't appear for trial. And in fact, Mr. Martinez is the chief witness for the state. If he does not appear, we have no case and we can't have a trial. And there's simply no evidence that he will not appear. In fact, the defendant didn't even allege that he would not appear. The defendant alleged only that he might not appear based on his prior behavior. But in these kinds of cases, the party who is asking for the deposition has to prove that the prospective witness won't be available for exceptional circumstances. So, for example, this court in the Gold case that I discussed in the brief, the issue in that case was a doctor who was going to be moving to Saudi Arabia, a place where the trial court's writ simply does not run. And the parties simply said, well, she's moving to Saudi Arabia, so I suppose she's not going to be available, but they didn't offer any evidence that would support the idea that she wouldn't come back if called, that it would be too expensive for her to come back, or for some reason that she would simply refuse the court's order, even though it really had no power in Saudi Arabia. There was simply no evidence. And so this court said, her moving to Saudi Arabia is not exceptional circumstances that would justify a deposition. And here we have, again, no evidence that Mr. Martinez will not appear. We have bare speculation, and that is all.
Does the fact that that in the civil case, which was talked about in some of these filings prior to this argument, that Mr. Martin has agreed to a deposition in the civil case, does that kind of make the whole thing, in a sense, their argument that there's a need for deposition in this case moot?
No, it doesn't, Your Honor, and for several reasons, which I pointed out in my filing that the court asked for. Primarily, The issue is the trial court's order is erroneous here. The trial court did not have the power to grant a deposition under this rule, and it abused its discretion when doing so. And secondly, even if counsel were to depose Mr. Martinez, there's no guarantee that he's going to be getting the kind of evidence that he wants or thinks that he needs for this criminal case. In fact, I don't know how much these cases overlap. It may not be, I don't know how the civil attorney for Mr. Martinez would object, maybe, if counsel for the defense were to ask questions that were pertinent in this criminal case but not pertinent in the civil case. He may be able to object to those. I simply don't know how that's going to go. And furthermore, even if the defendant were to obtain all of the information that he wants at the deposition, there's nothing that would prevent him from deciding later, I don't have enough evidence, I still think I need more evidence, and let's have this deposition anyway, or move for another one, and then the trial court repeat the same error over and over, which is why we really need this court to step in and to prevent that from happening. So no, that doesn't make it moot. I do want, in the time that I have remaining, to just kind of prospectively address some of the arguments that the defendant made in his brief. First of all, the state didn't waive its argument by not objecting to the defendant's motion for the discovery of documents. That's governed under a different rule. This is a deposition under Rule 15, and the state objected in writing and on the record, arguing Rule 15 and arguing the Supreme Court's case in Singleton. And so in that sense, the state didn't waive this argument. The trial court does not have inherent power to order a deposition because its inherent power is restricted by the Supreme Court's rules of procedure. It doesn't have the power simply to ignore Rule 15. And finally, the defendant waived his argument that the state lacked standing to object to his motion for a deposition. The defendant didn't challenge the state's standing in the trial court. He's waived that argument. Moreover, this court granted review of one question, and that is whether the trial court abused its discretion when it ordered this deposition. It did not grant review on a standing issue. Accordingly, the defendant has waived that, and this court should not review it. I see I have 3 minutes left for my primary argument. Does the court have any further questions for me? Otherwise, I'll reserve my remaining arguments for rebuttal.
Thank you.
Thank you, Your Honors.
May it please the court. My name is Ben Rose, and I'm here on behalf of the appellee, William Martinez. It's a pleasure to be in front of the court. I guess it's this afternoon now. And for Judge Ayer's benefit, since you weren't in attendance for the previous arguments, I had a fancy quote that I was going to start off with in terms of my argument, but I think I can fairly summarize the court's interest in this case by saying whatever the term means, it's probably not euphemoric about what I have to say. But there is an argument to be made, and I'd like to make that argument. To address Judge Dyer, I understand you've had a promotion from the previous arguments, and I'm just going to call you Judge. I hope don't hold that against me.
That'd be just fine.
But to address your two points that you made in terms of questioning my friend, one of which is in terms of the mootness, it absolutely will become moot. And the evidence of these other cases, almost all of which are civil in nature, I've been trying to depose Chris Martinez for 6 years in these cases. All of the cases from the very beginning of the litigation involving one of his other brothers, Joe Martinez, in Williamson County Chancery Court, from that beginning, these same types of allegations are exactly at play. So we would ask...
But haven't you just said your sole purpose is to take his deposition, which for our purposes of review is governed by Rule 15, and that's not allowed for discovery?
That's a good question. And what I meant by that, Your Honor, was my purpose in the civil cases is to take his deposition. I've been trying to do that for 6 years. In the criminal case, the purpose, and I can explain the trial court's ruling in just a moment, the purpose was not to take a discovery deposition under Rule 15. In fact, that's why it's not referenced within the order from the trial court. There is no appearance of Rule 15. In fact, in our motion, we even say that there are not discovery depositions that are typically allowed in criminal cases. The purpose of the deposition in this case was to satisfy the Brady obligations that the state refused to satisfy.
But that's as the state points out, I mean, your remedy under Brady is post-trial. It's not pre-trial. So, you know, you can't say, well, we think they are going to or have violated Brady, because they have until trial to disclose the information. I mean, they're supposed to disclose it as soon as possible, obviously.
Yes, Your Honor.
But they have until trial to disclose the information. So your Brady claim is a post-trial claim. You can't make a Brady claim, so to speak, and say, hey, we want to prove they violated it when they still have time to fix the issue if they don't have it. That's one. Two, you're asking them to turn over information, as I understand the state's argument. You're asking them to turn over information, one, that's contained within a witness's head. It's not a document. It's just his words, what he thinks, what he knows. But two, even if it is a document, they're not in possession of it, or, as I understand the trial court's order, they've turned it over already. So it is a discovery deposition, because you're trying to obtain information that the state may or may not have. I don't know how else you couch that as a discovery deposition.
If I may, Your Honor, first of all, with regard to the post-trial issue, we're trying to prevent that from happening. I understand, just like in Singleton, for example, they say, well, you know, you didn't get the benefit of a preliminary hearing. Your remedy, based on what I think was characterized as new evidence, was you come back on a post-trial motion to address that. And I'm trying to avoid that to where we have all the Brady obligations that are satisfied before we go to trial. I understand the procedure that I would do it after the fact, but what I'm trying to prevent is that from happening.
And under what rule and legal
Right.
authority are you trying to make that happen?
Well, it's under my understanding of constitutional discovery, not discovery for purposes of developing the case. The other point that I would make, Your Honor, is no, I'm not seeking information that's in Chris Martinez's head per se. What I'm seeking is what I would call secondary exculpatory information or documents that Chris Martinez has.
Which the state's not in possession of.
Well,
According to if I understand the trial court's ruling, the state hasn't violated Brady. The state's not in possession of this, but she's allowing you to do a deposition so you can get possession of it. Well, it's not even a Brady. If the state doesn't have possession of it, this isn't a law enforcement officer where you can turn around and say they have this knowledge of it, whether it's in their file or not. This is a witness, so it's not a actor of the state. They may or may not have the document.
yes, Your Honor, if I could address that. To be clear, I was going to go to the basis of the trial court's ruling. And Judge Ayers is correct in reviewing the order. It was a simple order. It essentially says because of the unique circumstances of this corporate embezzlement case, the court found that a deposition for Brady purposes was appropriate. And our argument, just so the court knows how in the record this comes about, we filed what I would call conventional Brady motions to look at certain types of property that Mr. Martinez, my client, had been accused of stealing. Those motions were denied. Essentially, the state's position was that they produced the whole file. In a corporate white-collar case of 10,000 or more documents, and I don't know how many computer files, they just produced everything. And that was supposed to satisfy their Brady obligation. I filed a motion to challenge that. Our arguments were, number one, if you produce over 10,000 documents relying on federal precedent, it's not satisfaction of your Brady or Giglio obligations to just warehouse a bunch of documents and not point out where those are potentially exculpatory. And just for a practical example, for example, there are credit card receipts, and you could look at the credit card statements or receipts, and you can see where similar items have been purchased for other than business purposes by other parts of the company. But there's no backup to that. There's no actual invoice. There's no approval that they're accusing my client of not having corporate approval to purchase. It's that kind of material. So I asked for that in terms of the warehousing. And then I also asked for, wait a second, we have a whole line of cases in the federal jurisprudence that says if the state knows that there is potentially exculpatory information or documents that's out there, the state can't just say, well, here's our entire file, I respectfully submit, and You go figure it out. What our argument was to the trial court was that that necessarily implicated additional exculpatory documents and information, some of which Christopher Martinez had, that the state should produce. Now,
But well, first of all, do you have a state case that says that?
I do not have a state case that says that, Your Honor. Again, the constitutional discovery argument is based upon federal jurisprudence. I would also say that there's not a state case that says we can't do that, having reviewed
But
this.
there's a Supreme Court rule that says you can't do it.
You're referencing Singleton?
Well, I'm just saying you can't, there's a, well, I say Supreme Court rule. There's a rule that says you can't have a deposition in a criminal case except for under certain circumstances.
Yes, Your Honor.
There's a rule that directly contradicts everything you just said.
Respectfully, Your Honor, with regard to Rule 15, that is a discovery rule, which again,
You keep trying to, and I promise, but you keep trying to differentiate somehow Brady from discovery. They're one and the same. So you keep saying we want to get this Brady information, but this is not a discovery deposition. You can't have those two things.
Your Honor, please, we just see it differently. We see that there is discovery, which is not allowed typically in cases in criminal courts in Tennessee, and we see that there are constitutional.
What's the purpose of Brady?
The purpose of Brady, as I understand it, Your Honor, is for my client to have full assessment of potentially exculpatory information or documents so that he can put on an adequate defense and for purposes of due process.
And he gets that through the discovery process with the District Attorney General's office, correct?
I would say it's constitutional discovery, yes, Your Honor.
Okay. What's the purpose of this? What's the purpose of this deposition if it's not for discovery? You can call it Brady, you can call it constitutional discovery. The rule says, and the comment to the rule says, you can't have a deposition in a criminal case for the purposes of discovery. I just don't see where the differentiation lies here, and especially based on the ruling by the trial court, I don't know how she got to this point.
I'm not ignoring the comment, Your Honor. I want to come back to where the trial court was coming from because I think that's important. So we made that argument with regard to the warehousing and of what I would call the secondary exculpatory information not being produced. The trial court didn't agree with us on that. The trial court also didn't agree with the state on that. The trial court held that issue, if you will, in abeyance. And in the alternative, first of all, the court did two things in the alternative. One, the trial court gave us the ability to discover documents from Chris Martinez and from other entities that would go to this very question. And there was absolutely no objection. I know it's a different rule, but there was no objection from the state based on, oh, you can't do that. This is constitutional discovery, anything like that at all. There was no objection, and I submit respectfully, a lot of our issues have to do with those documents, and I believe the state has waived that issue when it comes to the documents or the subject matter thereof. The other thing that the trial court did, being put in this position of, well, I don't want to try to litigate how the state is supposed to investigate its case, on the one hand. On the other hand, the court didn't want to leave Mr. Martinez without his potentially exculpatory information having been disclosed in whatever manner, and we could argue about whether that's constitutional discovery or not. And that was the basis for the court's order to allow his death.
Under the argument you seem to be making and the trial court seemed to follow, let's create a different hypothetical. You have some other criminal case, and a state's witness refuses to talk to you or your investigator when you go to interview them. Can you order their deposition because they refuse to talk to you?
I don't think so. Under what that's Singleton basically is whether or not you can. And let's be clear, because I think I don't want to mesh the concepts. I mean, Singleton was about interviewing police officers.
Okay, I'm just talking about. I'm talking about a non-state actor witness.
Okay.
A non-state actor witness in any other criminal case refuses to talk to you or your investigator. Under what authority, if any, could the trial court order them to talk to you, order you to take their deposition?
If the state has not complied with its Brady obligations and produced all of the information that's exculpatory or potentially exculpatory.
Okay, under what rule or what case do you say that the trial court can order that deposition of that witness who refuses to talk to you for the purposes of Brady?
Brady and Giglio, and there's a whole line of cases.
Pre-trial.
Brady and Giglio, Your Honor, is the way I would submit. And we've briefed the way that works in a number of different jurisdictions that have taken up the issue. I understand the court wants to go back to Rule 15. And again, I'm the first one to mention Rule 15 in our motion for a deposition for constitutional discovery purposes and saying that you can't take it for discovery purposes. So I understand that. But I understand how we want to make Rule 15 global for all discovery. But with respect, Your Honor, Rule 15 does not address Brady. And in fact, if you look at the language for the exception of Rule 15, it talks about where justice requires and for exceptional purposes. That is Brady language, clearly contemplating an exception to the general rule.
Okay, take Rule 15 out of it then.
Okay?
Cite me one case, one statute, one rule that says in Tennessee, if a witness in a criminal case refuses to speak to defense counsel or its investigator, the court has the authority to order that witness to be deposed.
I cannot do that, Your Honor, because it's in Tennessee, because that's a issue of first impression in the state. There is not, as I understand it, a constitutional discovery case at this point that holds in that manner.
Okay.
Because it's not addressed. Now, there's a way to get there, and I'm happy to explain how that works.
I would love to hear it, please.
Yes, Your Honor. So again, I may not be able to convince the court if the court equates all discovery being the same. I see it differently, and again, I mentioned Rule 15 from the beginning. We submitted to the trial court. We understand you cannot take general discovery in a criminal case under Rule 15 except for exceptional circumstances when justice requires. I submit that there is a different type of discovery that you can take, constitutional discovery, to satisfy Brady obligations in a unique case such as this. We heard a number of cases for this morning's docket that are not like embezzlement corporate cases, white fraud cases involving 10,000 documents or more and who knows how many computer files. This is a very unique case and would be something centered to this specific case where we believe the record demonstrates, and it's part of the reason we also had the entire file submitted as part of the technical record, because you could go back and look at that and see how it implicates additional exculpatory information in the same way that the rule talks about statements of defendants, for example. If the state knows about a defendant's statement that exists or that could exist, the rules recognize the requirement for the state to submit that additional information as part of their Brady obligation.
And these other jurisdictions that you keep referencing, again, going back to one of Judge Dyer's prior questions, is any of that pre-trial like this, or isn't it typical post-trial Brady resolution issues?
There are a number, and I guess the best way I would say, Judge Ayers, is that I would refer you back to our briefing on that demonstrates the other jurisdictions that allow this type of discovery. That's the best way I would reference it. And how they get there, I know we want to talk about specific rules, but admittedly we cite, much to my chagrin sometimes, some secondary authority in terms of case notes and law reviews and things like that. But if you go back to when this idea developed back in the 50s, when certain jurisdictions were looking to do things like this because they see Brady coming and they see Giglio coming, I think, respectfully, there is a method that we have briefed completely that says, look, the federal rules, for example, there are certain federal rules that govern this, and it essentially kicks the obligation to comply with Brady to the trial courts within their discretion. We have cases like that in Tennessee in certain circumstances before we had formalized rules where the trial court within its discretion, when justice requires, has to provide certain types of information that the state has. If you go through that formula here in Tennessee, for example, that rule, the federal rule that our rules were based on, they did not adopt that deference, if you will, to the trial courts explicitly. If you look in our criminal rules, that rule does not specifically appear. But what you see is the Supreme Court has delegated those types, I would respectfully submit to the court, authorities to the local rules within this jurisdiction. And there's nothing within the local rules that prohibits this trial court, for purposes of Brady, when justice so requires, to order this type of deposition.
Mr. Rose, let me ask you, it sounds like a lot of what you're searching for here are documents in the possession of a private citizen, a third party. That's accurate.
It's a big part of it, yes, Your Honor.
Why are we talking about a deposition and not a subpoena ducis tecum under Rule 17?
Well, that's not an issue, as I understand it, from the Rule 10 appeal. As I understood it,
Well, it's not, but I'm just saying, you're agreeing that Rule 15 doesn't apply if this is what you're searching for. And I'm not saying that a subpoena would properly issue under these circumstances, because, as you noted, that issue is not before us. But if that's what you're looking for, instead of plowing all of this new constitutional ground here within this state, isn't that a more viable option for what you're searching?
I think it's an option. And if the court is going towards the issue of mootness, I think, assuming that we're allowed to do it, because I think we may be up here again on the issue of documents as I understand it, but assuming we're allowed to do it, it would, between that, Your Honor, and frankly, the taking of Christopher Martinez's deposition in these other cases, which we're shooting now for a May 26th potential deposition date in Arizona, those two factors, I think, would totally moot this case, completely moot this case. But here we are, and I've got to argue and defend the trial court's order, and I think it's a defensible order because I do think she made the appropriate constitutional decision as justice requires without even talking about Rule 15 at this point.
But that's not what the order says, really.
Well, with all due respect, Your Honor, I haven't looked at it in a while, but I think it says something to the effect of you are right, there is not a specific finding that says I'm doing this for a specific reason. I think as I understand or recall the order, it's to the effect of, in this unique case, based upon the motion and adopting the position that we put forth in the motion to allow the discovery, I believe was the rationale. And there's also, I think, a transcript that was either was in the record or should have been in the record in that effect.
Yeah, it's based on the contents of the motion and the state's response to discovery thus far, the uniqueness of this case granted relief.
Yes, Your Honor. And if you look at if the question is, well, we're not sure that's enough, and maybe it's not, maybe we need to send it back for the trial court to revise the reasoning, I don't think that's necessary, because if you look at our motion, the arguments that I'm making before this court today are the exact same arguments that I made in the trial court below.
Even if we wanted to say, somehow Brady and constitutional discovery and these terms that you're throwing out allows for this, I still am having trouble trying to figure out how Brady comes into this if it's not a state actor. The state doesn't have possession of it. The state may or may not even know what's there yet themselves. I don't see how you can claim this is a Brady issue until the state has control of it, has knowledge of it, and is therefore not turning it over.
Yes, Your Honor, if I could address that briefly, I have about 15 seconds. So to give a very practical example. So one of the claims by all people made by Chris Martinez's was going to be ex-wife, but now apparently have gotten back together, is that Chris Martinez embezzled in the same way that my client, William Martinez, has been accused of embezzling. The state knows that. They know that, and that's just one example, because I provided that backup to them. The state knows certain aspects of this case that they would like to just say, well, we've turned over our entire file, and even though we know things that are in our head or through interviews, we don't have a requirement to provide you with that information or with information that could implicate potentially exculpatory materials. And that's what we seek in our original motion. We saw it in our original motion, and subsequently we were given relief in the form of the documents and the subpoena for the deposition. So Your Honor, if the court concludes, look, we think you just can give an open file and you've satisfied your Brady obligations, then I'm not going to have a very successful argument with the court. But if the court looks at some of the authorities that we've relied upon and concludes, as I did, which is why we filed the motion, and says, look, these materials, look at the record, these materials implicate additional documents and knowledge of other individuals, such as Chris Martinez, that the state knows are there and should turn over, but they're not doing it, then that was the problem I had, and that's why I filed the motions that I did.
Okay.
And I'm out of time.
Well, I still don't, the state may know they're there, but if they don't have possession of them or a way to get them, how do you expect them to turn that over? And that's what Brady's about. Brady's not about, what they may be able to grasp and find one day. It's what they have and what they fail to turn over.
I guess it depends on what we're talking about. If we're talking about documents where you have physical possession issues, I get it. The state says, well, we don't have those documents, we can't turn them over. But the problem I still have is they have turned over documents, voluminous documents that they haven't identified specifically that are exculpatory. We've got authority on that they should do that. And there are documents that implicate. So at a minimum, I would expect the state to come back and say, you need to look at the cash receipts or the company policy approvals on these types of things to direct my client to potentially exculpatory information. It's easier as it relates to just information itself, because if they've talked to, and I know they have, Chris Martinez, and he has revealed things like I just did about his marriage or those types of allegations, the state knows. The state knows, and I think they're required to produce that under my understanding of Brady and Giglio. Thank you, Your Honors.
Thank you. Rebuttal from the state?
Thank you, Your Honor. First, I want to point out that the trial court did order Mr. Martinez to produce documents. So we have that order. And the state didn't oppose that order. That's something that the trial court ordered, and so we assume that Mr. Martinez is going to produce those documents as he's instructed to do. What the trial court can't do is order a deposition. That's a very, very different matter. I'm going to read the advisory comment to the rule. I know that the court knows this, but I want to read it. Depositions are not meant to function as discovery devices in criminal cases. Their taking is meant to be tightly confined to those exceptional cases where the interests of justice require the taking for the preservation of testimony for use at trial and not for discovery. And again, the defendant has offered nothing that would suggest that his intent is to preserve Mr. Martinez's testimony for trial.
What about the defense's argument that there's knowledge in the state's head, so to speak, based on their interviews with the brother, and that there's at least federal case law out there that says you can kind of do a preemptive Brady issue by forcing you to turn over information that's not necessarily in your possession, but you have knowledge of?
I don't know of any case that says we can turn over information that we don't have, that we have some obligation to investigate a case in any particular way, or that, again, that we have to somehow give him information that we don't have. But I want to read, this is Rector versus Johnson, 120 Federal 3rd, 551. And this is a Fifth Circuit case. It says, the state has no obligation to point the defense toward potentially exculpatory evidence when that evidence is in the possession of the defendant. So what the defendant is essentially saying is, look, this is a big file. And therefore what the state should do is tell us, essentially do what defense counsel typically does, which is comb through that file and look for exculpatory information. He's saying it's so big that we can't do that. The state is in the better position. So that's what the state should do. I would argue that, one, the cases that the defendant relies on, first of all, he relies primarily on a sort of a law review article from a magazine out of Alabama. Second of all, the cases that he relies on are very unique, and some of them have not 10,000 pages, but we're talking about millions of pages of documents. And third, the general rule is what I just cited in Rector v. Johnson, that the state doesn't have this kind of obligation to point all this stuff out to the defendant.
Didn't the trial court rule that in a different order or a different hearing?
I don't remember, Your Honor. I'd have to look back at the record to see if the trial court ruled on that particular issue. But the fact is, insofar as these are unique cases, and the court, as the defendant looks at these cases, the court has kind of these courts accept that this is sort of an exception to the rule because these are really, really exceptional cases. But insofar as, I don't know that all of the circuit courts even do it this way. I think if anything, there may be a split of authority on that. And as this court pointed out, there's certainly no state of Tennessee case that requires the state to go through its entire case file and then and point out all the exculpatory information. I think ultimately that ends up being a dangerous proposition, because what would end up happening inevitably is, assume we have that rule, the state would then go through its case file, point out everything that it believes is exculpatory and material, hand it to the defense. the defense would then do what the defense would do and would go through the case file on its own and say, oh, look, here's one thing that you didn't point out, and now we have to have a new trial. And I think that would lead to just the floodgates being opened for a litany of litigation. And regardless, here, it's still discovery, and that's the point. And so again, the rule is very explicit. That discovery is not allowed.
I want to quickly go back to something you just said about in their possession, when you're talking about if it's in their possession as well. I mean, as I understand the case, and this kind of goes a little bit far of what the issue before us, but still want to ask it. You know, these are two business partners. So one of the things he said was, well, we need such and such a manual or such and such. Would he not already have that possession of that, of expenditure, how things are expended or allowable expenditures in the company and those types of things?
Are you asking if the defendant might have that?
Yes.
As a former employee of the company, he very well may. So I mean, so much of this information is information that is either belongs to Christopher Martinez that he may. I mean, if he has handed it to the state has already disclosed it. If he hasn't handed it to the state, I see my time is up.
You can answer.
If he hasn't given it to the state, then it's not in the state's possession, and Brady simply doesn't apply. So unless the court has further questions, again, the defendant concedes that the purpose here is not to preserve Christopher Martinez's testimony for trial. He's offered no evidence that exceptional circumstances are going to prevent Mr. Martinez from appearing and testifying at trial. Rule 15 governs depositions. It has those requirements. Those requirements were not met. The court's order granting the deposition was an abuse of discretion, and the state asks this court to reverse and vacate that order. Thank you.
Thank you. Does that conclude our morning docket?
Yes, Your Honor.
We will stand in recess until this afternoon.
All rise.